When petition and response are filed, but no movement on your case, how to move your case forward. So we'll get clients who have 3, 4, 5, 6, 10-year-old cases. They are amicable. Maybe they're not. Maybe they were amicable and now they're not. But a petition was filed and the respondent filed a response. In LA County, they have basically what I'm suggesting you do is get the court involved at this point instead of just leaving it up to the two of you to say, hey, we're not making any progress. The court's not going to get involved unless you ask them to in most cases. So there's a document you can file called request for trial setting. Doesn't mean you're going to go right to trial. So I don't want you to feel like you're requesting a trial. It could ultimately end in trial, but not in the very near term. It's basically a trial setting. The setting means there will be a court date established, usually in 30 to 60 days from when you file it, maybe longer depending on your court. But it's going to allow you to say, we're going through divorce and here's the issues we're having. Maybe you guys don't agree on child custody or child support or spouse support or property division. You would just mark those boxes on the trial setting request, file it. You'll get a court date. You guys will go. You'll get a notice to appear. You'll show up and you can say, look, we filed, you responded. We don't agree on X, Y, and Z. And the court will now be involved in pushing you guys through the process. The judge, after here's what you guys have to say, will make some decisions. Do I send you to mediation? Do I say take these following actions? Maybe you haven't done your disclosures yet. They will then set a path to completion for you and move you guys forward depending on your circumstances and how far apart you are in your agreements, and whether they think that might be trial, mediation, or some other source of court assistance. And the reason I recommend you do that is if you don't, you're just going to sit in the stalemate of no progress. This way, the court's now saying, on this date, come back to court, and by this date, have X, Y, and Z done, and then we'll reassess your case and see what to do